State Securities Enforcement Webinar, Focus, Impact, and Priorities. My name is David Pulio, and I'm with Foley and Lardner's Marketing Department. On behalf of Foley, I'd like to thank you for participating and joining us today in this web conference. Before we begin, we have a few housekeeping announcements. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget, which is open on the left-hand side of your screen. We will respond to these questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can get a copy of the slides in the resource list widget, which is open to your left. As a reminder, today's program is being recorded, and it will also be available on Foley's website in the next few days. Foley will apply for CLE credit after this program. If you did not supply your CLE information upon registration, please send it via email to me, David Pulio, at dpulio@foley.com. To be eligible for CLE, you will need to log in to the On24 session, viewing it on your computer screen, and answer a polling question which will be posted during the program. As a final note, those seeking Kansas, New York, or New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Please email the form again to myself, David Pulio, at dpulio@foley.com immediately following the program. Now, I would like to introduce our speakers for today. Terry Nelson is a partner and a member of a number of Foley's practices, including securities, commodities, and exchange regulation, private equity and venture capital, and the transactional and securities practices. Mr. Nelson currently serves as the Wisconsin liaison for the American Bar Association's Committee on State Regulation of Securities. Prior to joining Foley, Mr. Nelson served as Chief Examiner of the Colorado Securities Division and as Licensing and Regulation Examiner with the Office of the Wisconsin Commissioner of Securities. Joe Jacquot is a partner in Foley's Consumer Financial Services practice. Mr. Jacquot counsels companies in financial services, regulatory matters, and in any matter involving state attorneys general. His practice includes a wide range of matters, including investigation, litigation, federal agency action, and crisis communication. He has deep ties with attorneys general nationwide, as well as with Congress, having served as the Deputy Attorney General of Florida and Chief of Staff of the Attorney General's Office. We are also pleased to have with us today as a guest speaker Mr. Philip Feigin, Senior Partner for Lewis Roca Rothgerber LLP. Mr. Feigin's practice focuses on securities law compliance, regulation, and defense of the members of the securities industry in enforcement actions. Mr. Feigin was called away on an emergency this morning and will attempt to join us by phone for his portion of the presentation. At this time, I'd like to turn it over to Terry Nelson and wish you all a wonderful webinar. Thank you.
Thank you very much. Let's start by taking a quick look at some of the background of state securities laws and some statistics to demonstrate the impact of the enforcement of those laws. Excuse me just for a minute. Are the slides coming up on the live view here?
I believe they are, Terry.
Okay. At least they're not in front of me right now.
All right, then just give me an audio cue, Terry, and I'll push them forward for you.
An audio cue.
Just say next slide.
Next slide, please. Okay. Sorry for the interruption. The state securities laws are administered by state agencies, and some have large staffs and resources, more so than others. Some are more active in the enforcement world. What you see in front of you is a picture of the website from the state of Massachusetts, where it demonstrates, first of all, the state administrators' zeal in publicizing their enforcement actions, and also gives you a feel for what type of enforcement actions they take. In this case, the Secretary of State of the Commonwealth of Massachusetts, who is the head of the Securities Division in that state, notes a fraudster that was located in the state of Alabama. State of Massachusetts, in coordination with the Alabama Securities Administrator, has brought fraud charges with respect to that Alabama person. Next slide, please. State of Texas is also an active enforcement state. And here on their website, they describe certain recent enforcement actions. Might be a little difficult for you to read, but basically it's highlighting the fact that the state has taken enforcement action against a person who was recently indicted for fraud charges in connection with an investment scheme. And then the second person was brought up for charges on criminal sanctions for an oil and gas fraud scheme. Next slide, please. A very active state, of course, is New York. The Attorney General in that state over the recent years has been very active against fraudsters based in the state and fraudsters based elsewhere that are preying on New York investors. And here, this website highlights the Attorney General announcing a guilty plea and a prison term for a fraudster located in the Bronx regarding a $1 million Ponzi scheme. So each state has its own securities law and regulations to help administer that law. As I said, some states are more active than others, depending upon the size of staff and budget restraints. Next slide, please. Here are some statistics that have been compiled by the North American Securities Administrators Association, and they compiled information from the regulators of all 50 states regarding enforcement actions taken during 2013. You'll see that they took over almost 9,700 complaints from investors, conducted 5,300 investigations during this particular year, approximately 2,200, resulting in 2,200 administrative, civil, and criminal enforcement actions, or about 40% of the matters investigated resulted in some type of formal action. The states reported an increase in sentences imposed in criminal actions, resulting in over 1,800 years of jail time, 677 years of probation. The average jail term for a criminal securities conviction was 66 months. States ordered more than $616 million in investor restitution and levied fines or penalties and collected investigative costs in excess of $75 million. There were 746 outgoing referrals to state sister agencies and 587 incoming referrals from those agencies. Next slide, please. Although these numbers reflect enforcement actions only for 1 year period, some trends can be spotted. The most common problem faced by state securities regulators is the sale of unregistered and non-exempt securities, and the activities of non-licensed and non-exempt professionals. The increased use of the Internet and the lifting of general solicitation and advertising restrictions on certain Rule 506 offerings led to increased enforcement actions. This is an increased number of investigations against sale representatives of broker-dealers, and there is an increase in the number of license denials and conditioning of licenses for professionals. Next slide, please. This compares the number of enforcement actions on an annual basis over the last 5 years as compiled by the state administrators. It shows that the 2013 enforcement numbers across the board were less than in previous years, and this probably reflects the reduction in staff and resources to conduct investigations in many of the states. As the economy continues to improve, it is likely that state security authorities will have in the future a ramping up of the staff and resources, and thus there should be an increase in investigations and enforcement actions over the 2013 level. There is a strong belief among state regulators that the SEC, FINRA, and SROs are not doing enough in terms of investigating and taking enforcement actions against violators. Accordingly, state regulators believe that they need to help fill the void in enforcement actions. Next slide, please. This slide shows the amount of restitution ordered to be paid out to investors by respondents and the amount of fines and penalties assessed by year over the 5-year period. Again, 2013 numbers are notably less than the previous years, probably due again to the decrease in staff and resources due to state budget cutbacks. Next slide, please. This slide shows an increase in the years of incarceration imposed upon violators in 2013 over each of the prior 4 years. This reflects, in my judgment, the more aggressive approach by state regulators to refer enforcement matters to state and local prosecutors. Next slide, please. For the regulated industry, and I mean by that the professionals who are registered with the SEC and/or FINRA, this slide shows a huge increase in the number of actions against licensees in the form of license denials, withdrawals, revocations, suspensions, or conditions imposed upon licenses. There is every reason to believe that the number of state enforcement actions against the regulated class will continue to increase. Now, certainly in some of these matters, the states have chosen to impose sanctions against respondents who were the subject of enforcement action for the same matters by other regulators. In some sense, these actions could be referred to as piling on by the state regulators. I can tell you that most state regulators are not bashful about piling on. They are relatively easy cases to bring, as the primary part of the investigative work is already being completed by others, and respondents in such cases are less likely to contest such actions. Next slide, please. This slide shows the NASA compiled numbers by type of industry participant, and as you can see, actions against broker-dealers and their agents far outnumber actions against investment advisors and their representatives. Now, certainly there are a larger number of licensed broker-dealers and agents versus licensed investment advisors and reps, but and the number should be larger. But I think it also reflects, if you will, a regulatory bias against those who sell securities versus those who buy securities. Next slide, please. This slide shows the most reported products and schemes that were the subject of state enforcement actions for the 2013 year. I believe you will continue to see Rule 506 offerings, particularly those offerings that take advantage of the lifting of the general solicitation and advertising restrictions on Rule 506C offerings, and internet fraud. I think those will lead the way in terms of being subject to state enforcement actions in years subsequent to 2013. In order to fully appreciate the significance of the state enforcement actions and its possible impact in the future, and more importantly, how to more effectively represent clients in responding to state enforcement inquiries, you need to have a working knowledge of the authority for state regulators to take action and the type of weapons available for state regulators in enacting those actions. The state securities laws are commonly known as the blue sky laws. That name apparently comes from a comment by the U.S. Supreme Court in an early case where the court upheld the constitutionality of the state securities law and stated that such state laws were enacted to prevent speculative schemes which have no more basis than so many feet of blue sky. The first Securities Act was passed by the state of Kansas in 1911, and by 1929, nearly all the states had a securities law. State securities laws generally regulate the offer and sale of securities and the registration of those securities, fraud in connection with offers and sales of securities, the licensing of securities professionals such as broker-dealers, securities agents, investment advisors. Many of the state securities law provisions are similar to those found on certain of the federal securities laws, such as the Securities Act of 1933, Securities Exchange Act of 1934, and the Investment Advisors Act of 1940. Next slide, please. Enforcement of the state securities laws is conducted through criminal prosecutions, civil injunctions, administrative proceedings, and private civil suits. Enforcement through criminal prosecution has been a part of state securities laws from the very beginning and has been widely used. Enforcement by civil injunction was also available in the early state laws, but historically has not been widely used. The enforcement tools of administrative proceedings and private civil suits developed later on. The National Securities Markets Improvement Act of 1996, or NSMIA, preempted the authority of the states to require registration of most of the national securities offerings. It did not affect the state's authority to investigate and bring enforcement actions involving such offerings. Since NSMIA, state securities administrators have devoted an increasing amount of their time and resources to enforcement matters. The states generally focus most of their efforts on those sellers involved with non-federally registered securities and who are not directly regulated by the SEC or the SROs. Next slide, please. Some background on the Uniform Securities Act. This act was adopted by the National Conference of Commissioners on Uniform State Laws in 1956 and approved by the American Bar Association that same year. The Uniform Act has been adopted into law, all or in part, by 40 states. Commissioners approved a new act in 2002, the so-called 2002 Act, which was intended to modernize the Uniform Act by including, among other things, the regulatory changes imposed by Congress under NSMIA. Although there has been a concentrated effort by the Uniform State Law Commissioners and the state securities administrators to promote the adoption of the 2000 Act by most, if not all, of the states, only about a third of the states to date have adopted the 2002 version, and so far none since 2012. Next slide, please. Some noteworthy changes in the 2000 Act over the original Uniform Securities Act include a qualified immunity provision to protect a broker-dealer or investment advisor from defamation claims based on information filed with the SEC, state administrator, or SRO, unless the broker-dealer or investment advisor knew or should have known at the time that the statement made was materially false or acted in a reckless disregard of the truth or falsity of the statement. This section was primarily intended to protect broker-dealers and investment advisors while providing full disclosure with respect to the departure of employees. Secondly, new subsections were added to recognize the Securities Litigation Uniform Standards Act of 1998 rather, and civil liability for investment advisors. Third, two statute of limitation provisions, 1 year after the violation occurred for registration violations, and the latter to occur 2 years after the discovery of the facts, or 5 years after the fraud violation, to follow the current federal securities law statutes of limitations. And finally, a broad range of civil and administrative tools for the state administrator, including asset freezes, rescission orders, civil penalties, and cease and desist orders. All of the state securities laws, whether or not based on the Uniform Act, agree on a basic philosophy of regulating issuer offerings, the conduct of securities professionals, and the prohibition on fraudulent activity in connection with the offer or sale of securities. In many instances, the state securities laws require a lesser showing for liability than their federal equivalents. In defending state securities matters, defense counsel should be alert to the significant distinctions between the federal securities law and the state security laws at issue. Next slide, please. Section 414 of the Uniform Act, which is called the scope of the Act, is key to determining whether the Act applies to the Security Act activities in question. The activity that the administrator is alleging in any enforcement action or seeking generally to administrate over, or the activities alleged in a civil suit must have occurred in this state, as described under Section 414. The fraud provisions, broker-dealer and agent licensing requirements, securities registration requirements, unlawful representations concerning registration or exemption, and civil liability provisions apply to persons who sell or offer to sell securities when an offer to sell is made in the state or an offer to buy is made and accepted in the state. The fraud and broker-dealer and agent licensing requirements apply to persons who buy or offer to buy when an offer to buy is made in the state or when an offer to sell is made and accepted in the state. Generally, if the transaction has some connection with a state, then such state securities law will apply. It is not relevant whether either the purchaser or seller is a resident of the state, as long as the transaction, at least in part, takes place within the state. It is possible that laws of several states will apply to the same transaction. Any type of contact or negotiation which takes place in the state will probably result in an offer being made in the state. Prior to responding to a state administrator's request for information concerning allegations of illegal activity under the Act, counsel should first determine if the activities, which are the focus of the request, come within the scope of the administrator's authority under Section 414. This section is intended not only to address illegal activities directed on the citizens of the state, but also to those activities of persons who use the state as a base to conduct illegal activities exclusively upon persons residing in other states. Next slide, please. As stated previously, the Uniform Act provides 4 methods for dealing with violations or threatened violations of the Act: civil liability, criminal prosecution, administrative action, and civil injunction. A violator of the Act may be subject to civil liability under Section 410, criminal liability under Section 49, administrative action under 47, and civil injunctive action under Section 408. Note that under Section 409, the prosecutor must show that the violation was willfully done. The majority of the cases have held that the willfulness requirement is met by showing that the defendant acted intentionally, in the sense that he was aware of what he was doing. No intent to break the law is required to be shown. The first 2 methods are not used directly by the administrators as an enforcement tool. Oftentimes, however, the administrators will encourage or require by order violators to offer rescission to investors for transactions infected in violation of the Act. Also, the administrators may refer violations of the Act for criminal prosecution to the local district attorney or state attorney general. Investigations are usually conducted by the administrator's staff, but can be supported by outside personnel engaged by the administrator, such as attorneys, accountants, and other personnel. In addition, other law enforcement staff may assist in the investigation. Next slide, please. Section 407 of the Act grants broad investigative powers to the administrator. Section 407B provides the administrator with the authority to issue subpoenas. This is an important investigative tool used widely by state administrators. Most states do not have rules governing the conduct of securities investigations. The safeguards afforded in state securities investigations vary based on the subject matter of the investigation, the target's prior enforcement history, perceived urgency, historical practices followed by the administrator, the preferences of the relevant regulators, and applicable statutes and regulations. In many cases, the safeguards are less extensive than the practices afforded by the SEC and the SROs. The findings from a state securities investigation can have serious consequences. They can result in criminal prosecution, a temporary or permanent injunction, appointment of a receiver, imposition of monetary penalties, including but not limited to the payment of the state's cost of investigation, revocation or suspension of the licenses of broker-dealers, agents, investment advisors, and investment advisor representatives, and the revocation of securities registration or the use of exemptions. And of course, there's the bad publicity with respect to the name of the subject of the enforcement action is displayed on the administrator's website and maybe also be subject to a press release by the administrator. The investigation may be either public or private. Generally, the administrator will conduct an investigation in private. During the investigative phase, there is no public press release or announcement by the administrator. If the investigation is in the private stage, the information obtained during that investigation is confidential, subject to the right of discovery by a party in a civil, administrative, or criminal proceeding that may result from the investigation. Investigative reports and other staff memoranda may be privileged under the attorney-client and work product privileges or common law privilege for law enforcement investigative files. Once an administrative order is issued, then the matter is public, subject to media coverage and or press release by the administrator. Further, the administrator may share information from its files with civil litigants or other regulatory agencies. During the private investigation, the targeted investigation has limited rights. Accordingly, the target has no right to know who his accusers are, whether subpoenas were issued to others, and the content of such subpoenas, nor to cross-examine witnesses or to obtain a transcript of witness testimony during the private investigative period. Generally, the courts have agreed that because the investigation is supposedly non-adversarial in nature during the investigation phase, it is proper to limit the target's due process rights. Although the target lacks the usual rights during this investigative process, any witnesses called by the administrator in the gathering of information are allowed certain rights. Such witnesses have the opportunity to inspect and or secure a copy of the transcript of their testimony and should be advised that they have the ability to invoke their Fifth Amendment rights against incriminating testimony. Next slide, please. After the investigation has been completed, the administrator may decide to initiate civil or criminal enforcement actions under Section 408 or 409, initiate administrative adjudicative proceedings under Sections 204C or 306B, issue a cease and desist order, hold a public investigative hearing under Section 407A, or determine that it is unlikely that any violations of the Act have occurred or will occur, and close the file. Be advised that the administrator may not voluntarily report that the file has been closed. It often takes a follow-up call with the administrator or staff to determine if that is the case. Also, the administrator has the authority to issue a summary order based upon the administrator's belief of alleged violations. And generally, a summary order is issued when the respondent failed to cooperate to a request for information. If on the unlikely event that an administrative hearing is to be conducted, either at the request of the staff or the respondents, the public investigative hearing under Section 407A is a public proceeding. Public hearings can inflict substantial damage on companies and individuals that are the subject of the hearing. However, the administrator and the parties involved may consent to a closed hearing pursuant to Section 412F, and whether or not the hearing may be closed may be questionable based upon some of the state's open meeting laws. The administrator may publish his findings subsequent to the hearing. The public investigative hearings are often used by state administrators primarily to broadcast to the public a potential problem in the securities industry. I can tell you from experience that most investigative matters, once they have been completed, are generally resolved without a hearing by the respondents agreeing to the issuance of a consent order where neither admitting nor denying the staff allegations, but agreeing to the imposition of some type of sanction. Targets of inquiries or administrative actions should be mindful that the state administrators share information about possible wrongdoing of the targets and their activities with the state administrators of other states and with other state and federal regulators. Accordingly, a target who has activities in more than one state or contacts with persons located in more than one state may ultimately be the focus of investigations in several of the states due to the information sharing. That concludes my portion. Now, Joe Jacquot will talk about the role of state attorneys generals.
By the way, Terry, I'm here.
Thanks.
Hey, thanks, Terry. I appreciate your expertise on this. This is Joe Jacquot, and I'm here to fill the gap between Terry and Phil, so I'm going to take about 10 minutes and talk about a topic that is certainly relevant to securities enforcement, but goes much larger than that, and that is the role of state attorneys general. I was previously the Deputy Attorney General of Florida, and I've worked with all 50 state AGs for the past 8 years. I currently have a practice representing companies and associations before the AGs, and that's based on my relationship with each one of them. So what I'm going to do is just give you a little bit of background on the motivations and the practices of state AGs in this particular area. So this first slide, 43 state AGs are elected. 5 are appointed by the governor. 1 is appointed by the state legislature, and that's in Maine. And 1 is appointed by the state Supreme Court in Tennessee. Currently, there are 27 Republican AGs and 23 Democratic AGs. And I put this slide up here to demonstrate that AGs are as motivated by politics and policy as they are by the law. So if you are dealing with a state AG or multiple AGs, and you're approaching it only in terms of your legal arguments, you're missing at least half of the way to influence an AG, bringing politics, policy, at least a perspective on that, understanding that they are politicians, elected officials, they're seeking higher office, they care about what the public response is, the media response, and ultimately what they can do for their citizens and voters is critical in either stopping an enforcement action before it gets started or in resolving it. Now, this is a general slide just to give a bit of motivation perspective on AGs. And these are 3 points. 1, enforcers, particularly AGs, will follow the money. So if you are in a situation where you're looking at added or high fees, something unusual in terms of the structure, in terms of implications on a consumer, that is going to be a key enforcement signal. Second, enforcers listen to consumer complaints, and you want to put yourself in a position where you're hearing what the enforcers are hearing. So if you're in an industry or your particular business has been before the AGs and you're essentially above the radar for them, you're going to want to make sure that you're hearing all they're hearing. And third, enforcers will consider every consumer touch for their deceptive acts and practices statutes. And they're going to view that from the least sophisticated consumer perspective. So really trying to put yourself in the position not of the average consumer, but really of the one that hasn't been connected with your business previously, is the perspective AGs are going to look at this from. Now, before I move on, I wanted to just mention a couple things. Every state has got its own unique securities approach. New York obviously has the Martin Act with civil and criminal authority on securities fraud. I'm going to give a couple examples here. Maryland, the state AG actually does investigations for the state Securities Commission before it goes forward and conducts administrative actions. In Texas, the State Securities Board can investigate, and then upon investigation, it can refer cases over to the AG for civil enforcement. California, the AG does have a securities unit, but it works hand in hand with the AG's other consumer protection sections for civil enforcement. And in Florida, where I was the Deputy AG, we passed what's called the Investor Protection Act, which was really in response to the Ponzi schemes, Madoff in particular, and allows the AG to investigate criminal violations, working with the state's regulator, and for civil recoveries can pursue injunctive relief, restitution, civil penalties, costs and attorney's fees. So I give you that so that you see there's a different approach, and Terry hit some of this for each state. Yet, what I'm going to talk about over the next 5 minutes is states will instead most often use their unfair and deceptive acts and practices statute to pursue any alleged violations. And the reason why is that allows for multi-state investigations and potential settlements along a same common statutory basis, as every state has some form of deceptive practices statute. So here in this next slide, you can see exactly what makes up a deceptive practice. And what's key to notice here is that there is no knowledge or intent requirement. This is truly from the perspective of the consumer. I'm going to give you here just a list of sources that AGs look at for investigations. Certainly, private lawsuits is one that's particularly dangerous because the AG staff is going to look at those allegations and take them as is. It really doesn't give you an opportunity if all they're looking at is a complaint before any responsive document has been filed to see your side of the story, and they're not necessarily going to call you up before they begin to pursue something. Now, AGs use a number of different tools, and I'm happy to talk with anyone after this webinar, particularly about the multi-state process. I'm not going to discuss that today, but one tool I am going to discuss is something that most AGs have, and that's a civil investigative demand. Similar to a subpoena, but it is a statutory grant of authority to the AG based on the AG's role as protecting consumers. It's key to note that a lawsuit is not required for an AG to issue a CID. And in most states, all that's required is that the AG feels like the recipient has information that's reasonably relevant to the investigation. Could even be a so-called friendly CID, but this is part of the AG's toolbox in gathering information. The scope is investigatory, not discovery, so it isn't an opportunity to receive that information or other information back from the AG. In terms of investigations, this is really a quick shorthand in terms of dealing with the CID. And again, I'm happy to talk to someone offline about each of these steps and kind of the nuances in all of them. But aside from the things that you would normally do in terms of attorney-client privilege and ensuring that you have disengaged in the automatic deletion and you have your retention program set, one important thing to note with a CID from an AG is AG offices are very open to discussing them, the scope, the format, the timeline of response, hearing the cost implications, explaining to you the purpose behind them. So one thing you certainly would want to do is either through counsel that has a relationship with the AG or AGs to contact that AG or lawyer and get a handle on what they're really after here. They, again, may have looked at a pleading. They may have heard a news story. They may have gotten information off a blog, and you want to be able to fully inform them at least of your side of the story if there isn't a live issue here before heading down a costly road of response. Okay, so I've got just 2 examples here I wanted to hit real quickly of state AG enforcement in this area. This is a case that was going on when I was in the AG's office on municipal bond derivatives. And basically what you see here is the AG's using a Treasury regulation that the broker must certify compliance with as the basis for defining a deceptive practice. And then at that point, pursuing it as a 24-state, multi-state investigation and ultimate settlement with 5 entities. Oops, looks like we skipped ahead here. The other example is one that you may be very familiar with coming out of the mortgage crisis, and that is the role of the rating agencies, in particular here, Standard & Poor's. And this was a 18-state, multi-state settlement for $1.3 billion. And here, rather than the AG's relying on any particular statutory basis or regulation as a violation, they were using the company's own policies, and it's a violation of those policies that it put forth as deceptive, and that became the basis of the ultimate settlement here. Okay, so I'm going to make sure I hand it off to Phil to give him some time, and these are just some final thoughts. Just keep those AG motivations in mind. It's often tempting to approach them just like you would any other litigation, but they are political creatures, and you want to deal with them as such. Be mindful of the end game. Very, very few cases are ever litigated by AGs. They're ultimately settled, and you want to make sure you keep your option open. And third, think proactively. It's never too soon to engage with an AG, and sometimes the political mantra, make your friends before you need them, is valuable in dealing with these elected officials. So let me go ahead and hand it off to Phil.
Okay, hello everyone, and thanks to Foley and Lardner for having me. I enjoy being had. I'm going to echo some of what Joe said, and I will just begin by saying that as a state regulator for 20 years, and now in private practice, I've been on both sides of the aisle, and I'm going to try to give you some insight as to what goes on in a state securities agency and what's going to ring their bells, and also some current issues that I think we all need to be aware of in dealing with them, because in so many offices, federal securities law dominates. That's what everybody's really worried about. And state securities law is kind of left to an associate somewhere, and that's not a good idea. I show my students two steel bars as I begin my securities class, and show them that the bar from a federal cell is just as hard as the bar from a state cell. So looking back on history, blue sky laws really began things, but since the New Deal and federal law, they've been kind of losing ground. I've listed some of the areas where state laws have been preempted, but again, they shouldn't be ignored. The Jobs Act was the most recent area of preemption, and we'll be discussing that more specifically. Just areas to be aware of, although the very popular Securities Registration Exemption, Rule 506, is still out there and even liberalized, the new provision, 506C, that allows public solicitation, that's the good news. The bad news is that if you make a mistake, unlike with the old 506 and now Rule 506B, there's nowhere to turn. You will not be able to retreat to another exemption, and state law will not provide one, and I think that's an area where state regulators are now being very, very vigilant because they, frankly, do not like the concept of public solicitation. The area, however, where the states are becoming more active, as I have suggested in the slide, is, it comes up, with broker-dealers, and as I say in the heading, I think states have come to the realization that it's the secondary market stupid, that they are, in fact, spending a lot more time looking at market professionals than they are at securities offerings in the old registration mode. So broker-dealers are in their sights, and as I say, they really hate it when they see an unlicensed agent somewhere, because they believe it is so easy to make sure that everyone is licensed. So that's almost certain to get one in trouble. And the second area is the idea of finders to sell private placements rather than broker-dealers. When people sell securities without a license and get paid for it, states are likely to take umbrage at that, and most state laws include a provision that says the issuer that hires an unlicensed agent to sell securities is just as liable as the unlicensed agent, him or herself. So that is another area of state regulation that is important and to watch out for. But the focus of where I'm going to spend some time is on investment advisors. Investment advisor population numbers have increased for the states significantly since the amount of advisors regulated by the states increased from those with 25 million in assets under management to those with 100 million in assets under management. And what I'm seeing in my practice is a real conflict between these 25 to 100 million dollar advisors who were probably unlikely to have been examined by the SEC because of the amount of assets they had under management, unless they were firms with a specific practice that came within some program the SEC was running we have to look at all the advisors who were doing one thing or another. The SEC just didn't get to them. So you have advisors that have been in business for 10, 12 years and never been examined, and they can fall within this group. And now the states are out there showing up for the first time. Advisors are extremely proud of what they do generally, but the states spent most of their time at the $25 million level examining financial planners. A nice group of people and not overly complicated. But the new regime from 25 to 100 million gets the states into a different realm. And they are out to show that they can outregulate just about anybody on the block. They want to prove to Congress that not only should they have been given this authority long ago, they should have more, and they should certainly not vote for an SRO, a self-regulatory organization, over investment advisors. We can do the job better than the SEC and better than FINRA. So you have regulators with great zeal protecting with a view to protect their flock, their state investors, visiting investment advisory firms that probably have never been inspected, or at least many have not been inspected before, and the examiner's background is usually in financial planner exams, and you have very proud investment advisors who are being examined for the first time. Problems are bound to be discovered, and when these advisors get their deficiency letters and they see that they're being accused of violating the anti-fraud provisions or having engaged in a dishonest or deceptive business practice, or that they have violated their fiduciary duty to people, these advisors are likely to go nuts. They are likely to want to fight. They want no enforcement action taken against them, and they take great offense at the language of the deficiencies. It's just a very difficult confluence of forces, and the best thing I can suggest for investment advisors in that realm is to do whatever you can to try to clean up the shop before those state examiners arrive, because it is not going to be fun if they find problems, and they are likely to. Now, the next slide I had is a new realm and a new thing to be worried about from federal law and state law. And that is that for years now, most federal practitioners have had to deal solely with Rule 10b-5 private civil liability sections. And as most of us know, under 10b-5, either the SEC or the states or private citizens have to prove that there's reliance and causation under Rule 10b-5. That makes it hard for the plaintiff to prevail. There is a provision in federal law, 12A2, that used to be a more negligent standard, not requiring reliance and causation. But in 1995, in the Supreme Court case I reference in the outline, the Supreme Court ruled that 12A2, now it used to be 12.2, applies only to public offerings. And so with that decision, it meant that the only place an investor in a private placement could go to sue under federal law was Rule 10b-5, with reliance and causation required. That made it much more difficult to pursue such cases. There is a state law analog to Section 12A2, and a lot of practitioners aren't aware of it, or don't think of it either from a plaintiff standpoint or from a defense standpoint. And it has all the power of Section 12.2 without any of the exception of a Gustafson versus Alloyd. So it is out there, and it's important to consider it, because it can really sneak up on you and create problems. Further, from a federal law perspective, in the new Regulation A and federal crowdfunding, if it ever gets underway, the Congress ruled that Section 12.2 was going to apply to crowdfunding and new Regulation A plus offerings. So there may be a whole new regime of anti-fraud litigation at the private level, given the new applicability of 12A2. The next slide I wanted to point to is also troubling and scary, and that is the SEC's new Rule 506D, the bad actor rule. I won't go over the federal ramifications of this, except to say that if you are disqualified, it is a bad thing if you're in the securities business. And it's important to note that among the disqualifiers are final orders issued by a state securities commission, or bankers at banking commission, savings and loan, credit unions, insurance commission, and the CFTC and other banking agencies. And there is no necessity that there be a finding. That is a big difference from what we're used to in broker-dealer disqualifications. So It really means that if you are working on a case like Joe talked about and settling with an attorney general or the state securities division or whatever, they are very likely to include an anti-fraud violation. Those are usually the ones that they are most interested in. And if they insist on citing that provision in their final document, it may disqualify anybody affiliated with the issuer, including the issuer, from participating or using Rule 506 or Regulation D in the future. So it's important to note that to the regulators, nothing's changed, except now the ante has been raised significantly. Okay, I'd like next to turn to some of the insight ideas that I wanted to raise. And as I say, having now ruined an otherwise perfectly good webinar, what's going on in a way behind the curtain, or what pointers would I have to people being confronting a state examination or violation investigation? First is they're just doing their jobs as they see them. You would hope that the commissioner, the administrator, who is likely the most particular or the targeted person who is perhaps a political appointee or most responsible for agency decisions, has set forth some policies or ideas as to the bounds of investigations and the theory of why they're going after someone. But the line employees, I believe, get their inspiration from the idea that they are protecting their flock. They don't really care about policy from upstairs or anything like that. They are there to protect people from what they view as a voracious, horrible industry person. So you've got to try to, I think, gently turn them to realize that your clients, our clients, are people too. The next point is don't call your congressman. And by that I mean that trying to assert political influence because you know that you're a particular senator or representative, or you know the attorney general or something like that. First of all, it's very uncomfortable for those elected people to try to affect an investigation, but also it's likely not to be successful. The investigators are likely going to be now even more inspired, and it causes them, it's a signal to them that they really must have a great case going. So it usually doesn't help. Thirdly, what's done is done. By this I mean that there's nothing you can really do to change the past. And I can only look to Tom Brady to prove my point. The only thing that you can do is change what you're going to do in the future. And what I mean by that is you have to imagine your first impression. They have asked you, they're going to examine your office, or they've asked you for information. The nature of your response, is it competent? Is it well organized? Is it well thought out? Is it comprehensive? All those things can change the entire course of the investigation. Make it personal. I think you should get your client before the investigators as quickly as possible, because they believe that an evil person is on the other side. You have to make sure they're real people. Thirdly, again, they don't care how much it's going to cost. They usually over-ask, so you can probably negotiate that. And finally, peer pressure, as Joe alluded to. You don't know if it's part of a national campaign. They have peers to look to, and you have to try to figure that out to make as competent a response to requests as possible. And that is pretty much what I had.
Thank you very much, Phil. At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-digit code into the poll question on the screen in the slide area after it is announced, and press the Submit button. The code is GD4E2. That's G as in golf, D as in Delta, 4, E as in Echo, 2. And again, if you are seeking CLE credit for this session, please enter the code into the slide area and click Submit. You will need to enter this code if you are seeking Kansas, New York, or New Jersey CLE credit. In addition to entering the code, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the Resource List widget, which by default is open on the left side of your screen. I will leave us on this slide for another 20 seconds. Please enter the code. Again, it is, for the last time, G as in golf, D as in Delta, the number 4, E as in Echo, and then the number 2. All right, at this time the poll is now closed. I'd like to return the program to our speakers for our Q&A session, and would like to remind our attendees that at the conclusion of this program, there will be a quick evaluation survey that will appear, and we ask that you do stay and fill that form out to help us to make even better programs in the future. We take attendee feedback very seriously here. Thank you.
Hey, Dave, this is Joe Jacquot. I see one question that's come in. You want me to go ahead and answer that?
Yeah, go right ahead, Joe.
So, and I'll toss this up for Terry and Phil as well. How can a firm best convince a state regulator to follow the same settlement format as its primary regulator, example, SEC? The avoidance of a fraud charge or suspension from the SEC is all for naught if a key state insists on a more draconian result. And I'll be very curious to hear what Terry or Phil have to say, but I'll say from my perspective, the AGs are certainly contributors to what has been referred to as swarm litigation. So think killer bees, where you have multiple federal regulators, sometimes multiple state regulators and enforcers, all seeking a penalty for the same act. And, I think this is a problem. I think, in some sense, yes, it's nice to wrap up your liability in a complete sense, but the penalties that are being extracted for one alleged violation from a multiple number of entities is really, I think, over the top. So, but Terry and Phil, please jump in.
Well, this is Phil. I think, and it depends how narrow the investigation is, but I believe the best thing to do is involve the state regulators in the process as early as possible. I think it's not unusual, but at least in many cases, the SEC will have at least let the states know that something is going on. But it's the same problem with private liability when the securities agency is proceeding and at the same time that there's criminal exposure. How do you get all three issues resolved at the same time? And that's very hard to do. But basically, if you can get the state regulator, securities regulator, involved as early as possible in the process so that the resolution is likely to be comprehensive as opposed to SEC first and then the states later, that's a hard row to hoe.
Yeah, and this is Terry. It's kind of the piling on. Well, it is the piling on that I talked about in my presentation, where just because another regulator has taken action for the same offense doesn't mean that state regulators aren't going to issue their own orders, and I call that piling on and unnecessary, frankly. And with some success, what Phil is saying is get the human side of things here in front of the administrator, and get it in front of the administrator as soon as possible. Look, point out to the administrator what sanctions have been imposed by the SRO or the SEC and the impact on this person's life and livelihood. Sometimes that works and gets them to decide not to take action, but it's a very, very difficult situation where you have state administrators are trying to add to their enforcement numbers, and these are easy cases for them to bring.
I think at the very last part of my presentation and also in Joe's, if anybody's having difficulty in a particular state, I guess it's important to understand what's going on there. Is it a political situation? Is it somebody trying to show everybody that they're tough because they just took office and they're tougher than the last guy? There is competition between agencies at the state level, among colleagues. One attorney general might want to be tougher than another attorney general. One secretary of state may want to be tougher than another because they're thinking of the stats they can prove in another election or the next election. So understanding the motivations that might be behind these things might help you understand a solution, or if worse comes to worse, at least from a lawyer's standpoint, be responsive or guide you on telling your client what the expectations might be. But you have to find out what might be motivating them to maybe come up with a solution.
And I do believe that is the extent of the questions that we've received so far.
Now we got one more. We got one more about crowdfunding.
There we go. Yeah, I think this will have to be our last question for the day. If our attendees do want to send more questions, we will try and follow up at the conclusion of the program. But yeah, let's take this one last question on crowdfunding, and then we will conclude this presentation.
Crowdfunding. At the state level, there has been a long-standing question answered in only a couple of states as to whether the Attorney General enforcing a unfair trade practices law, consumer protection law, has jurisdiction in addition to what the state securities regulators might have under their Securities Act. And I can just say that most of the time, the Consumer Protection Act people are kind of back off when it involves securities, but not always. And it may be that that's another thing that you have to accommodate. If the regulator doesn't like something you're doing, they'll probably find some jurisdiction to figure out how to go after it. So when the FTC is going after crowdfunding under 506, if it's deceptive, I think you're going to have a problem.
All right, and it looks like we are receiving a couple more questions, at least one more question, and I think we can answer this last question that we've received. If attendees do need to leave for to attend to their own schedules, again, the recording will be made available on Foley.com, and we will contact you with a copy of that recording. But let's go ahead and continue to answer questions as they are still coming in here. It looks like we received another question about inside counsel meeting with state regulators. What do our presenters, if they want to check this question out, have to say about that topic?
My response is now. I would proactively go. Now, this is assuming you're not under examination or investigation right now. But if you're someone in the industry, I think it's a great idea to go visit, introduce yourself to the regulators, and get to know them and understand them. That used to be the idea of going to NASA meetings. Now, not everybody can afford to do this, and if you're in a big state, that can be more of a trip than otherwise. But I think it's very important to get to know people and understand them and have them understand you. So I would encourage it.
Yeah, and I'm sorry. Go ahead.
Counsel, I wouldn't worry about outside counsel. I always think that raises the ante. Makes them uncomfortable, but that's up to you.
I would say this about outside counsel. I think it's good if you can find outside counsel that has at least a working relationship and a familiarity with the state administrator. I do think that gives you an advantage because they know the law and they know the workings of the staff, and that could be helpful.
I agree with that.
All right. Well, I do think that concludes our Q&A session, and that also concludes our presentation. I'd like to thank everyone again for joining us today. And if you have any further questions, do feel free to reach out to us. We will be sending a follow-up email with our presenters' contact information and a copy of the recording of this presentation. Thank you all again. Have a pleasant day.